Welcome to the Defence Property Podcast, the podcast where we talk about all things property investing and real estate for Australian Defence Force personnel. Whether you're looking to build and scale a property portfolio or relocating across Australia, we've got the insights and tips for less stress and more success. Let's dive in.
So welcome back to another episode of Defence Property Podcast. Today we have a special guest, Mary from MNM Property and Commercial Lawyers. Mary, welcome.
Thank you. Thank you for having me.
So before we kick off, today we're going to talk about some risks and ways to mitigate said risks when we're buying property sight unseen, interstate, or maybe we're relocating from around the country. But before we do, I'll hand over to Mary and tell us just a bit about yourself, your background and the business.
So I am the founder and director of MNM Lawyers. We have been up and running for about almost 3 years now. We do deal with, obviously, as our company name says, a lot of property and commercial law. And part of that, we do a lot of buying and selling of residential, commercial, industrial premises. And I guess throughout my career, I have seen a lot of legal traps that buyers unfortunately get themselves into. So I think there's a lot to discuss today.
Yeah, awesome. Can't wait to get into it. And for the listeners and many of our clients that have used us in the past have obviously dealt with Mary, and conveyancing is one of those, or property law in general, but conveyancing on the resi side when we're buying is one of those things that when it goes smoothly, anyone can do it, and there's no, but when it turns ugly and you get into a fight, and many of our clients have heard me when I've explained or introduced Mary to our clients that we don't use the cheapest, but we use someone that we've seen in a fight, because when it comes to an argument, you want to be offensive and not defensive when it comes to it, because stakes are high, I guess. So, but kick us off, Mary. What are we on? What's the first topic and what's the point that we'll go through?
I think the first problem when buying property unseen is the actual property condition itself.
Yep.
Right? So a buyer hasn't gone through and actually walked through the property to physically see every little bit of that property. So there could be defects that aren't actually shown in photos. There could be misleading or selective representation by the selling agent. And what I mean by that is taking a great photo of one side of the house, but omitting the other that has a hole in the wall or whatever the situation might be.
I really love it. There's all these online, like digital staging of properties and stuff.
Yes.
And then you've got like obviously editing, so the editing these days is amazing. But yeah, so I often explain to clients, like as a business, like a buyer's agency, we do a lot of buying in the state, and we can buy off market, where generally the photos when it's off market could be 2, 3, 5, 10 years ago, depending on when it last went on. Online, for a rental, or online for a sale. That's the photos that would generally pull through to the on market, to the off market. And then when we are selling on market, obviously the risk there is the digital staging, the editing, and that. So the online photos never really, paint the full picture or give you a good understanding of the property condition. And how do we mitigate it?
Yeah. So I think first, we always want to make sure that any buyer has legal representation to review that contract before they enter into it. We can obviously draft special conditions. Part of that is putting in a special condition that allows the buyer or their buyer's authorized representative like yourself to actually physically inspect the property or have some sort of video run through live, and that could be within the first 7 days of the contract, making sure that the buyer is actually satisfied with the condition of the property itself. But I think more so than that, a lot of this risk actually lies around the property itself, around the contract itself. And I think it's absolutely critical to have a lawyer review it in advance, because it is at that point in time that we can discuss, I guess, the buyer's situation, whether they have seen the property or not, and any other special conditions that they might require. So if you're not seeing a property live, you haven't gone in to check the oven, check the stove to see that they're actually working, well, we can prepare special conditions that require all of those appliances to actually be in working order at settlement. So you can go back in, get those checked. Because unfortunately, changing an oven isn't cheap, and that's the last thing you want to do
100%,
when you've just moved into a brand new home.
Yes, taking a step back to We've found the property listing on or off market. We then present that to, the buyer. They can see, the listing, which gives them, the address and some basic details. We then organise a video walkthrough pre-offer negotiations and purchase. And at that point, we're happy to proceed. Negotiations start. Part of the negotiations are the contract review and preparation with any special conditions. So we're going to put in a couple of special conditions. So like the oven, the air cons, quite expensive items. So the working order, which you obviously know that we always put in for every client every state, but we'll sort of concentrate on Queens and your state of operation. What other special conditions are we when we're in that review phase of the contract? What are we looking for and what can we sort of mitigate or protect the client from?
Yeah. So I think the things that come to my mind are allowing like a 7-day physical inspection if the buyer wants it, making sure that all appliances, including any included chattels, so if the seller's also including in a microwave or whatever else they're including in that purchase, that they're actually in working order at settlement. The one that I think is absolutely critical is a due diligence clause. We call it our property searches clause, where we undertake a lot of property searches to find out, I guess, the legal side of what's hidden in the background. Some of those searches, I think, are well worth the money. It's a very big investment that a buyer is making, and those searches can range anywhere between $50 to $200, and it can save them thousands or hundreds of thousands of dollars down the track. So, for example, when we do buy a standalone dwelling, I think two that come to my mind right away is the Department of Transport and Main Roads search. That's about $50, and it'll tell us whether there's any resumption plans, because
I just want to jump in there, break it down for us, like for the listener. What's the resumption plan?
Yeah. So like imagine you're buying a lot that's 800 meters squared.
Yep.
And now the Department of Transport and Main Roads wants to come and take 200 meters of that. Well, is that property really worth it anymore?
Yeah,
or
well, you've definitely decreased the
price?
value of the...
Yeah, so that would give us a right of termination or compensation depending on what the buyer would want to do. Another one that is absolutely critical is the QCAT search. It's only about $40, and it'll tell us whether there's any trees or fences disputes. Unfortunately, those disputes travel with the land. So if you become the owner and there's a dispute regarding a tree or a fence, you now inherit that and have to continue that dispute.
I think fences and fence lines or building or replacing fences would have to be one of the number one causes of neighbourly disputes.
Oh, yeah.
Yeah. So we're not buying someone else's problems when we buy the property.
Yeah. And just like, there are some critical searches for standalone dwellings. And I think when you're buying within a body corporate, it's absolutely critical to do a body corporate record search. We have a body corporate investigator that we work with who pretty much scrummages through every single piece of document that the body corporate has. First of all, find out, are they cash flow positive? Are there any special levies that are coming up? Are you going to be stepping into a scheme where they're short on money and now you need to fork out a bunch of money from your own pocket to top that up? In addition to getting the minutes and things like that, but it just gives you a really good understanding of how that complex or scheme runs.
I just want to jump into the special levies because I think that's something that's probably going to be more common out of, the things that you mentioned, and it's something that I've had exposure to in our portfolio.
Yeah.
But the special levies, like let's say a large complex, maybe 4, 5, 6 levels, and there's a lift. So the special levy will be like there's not enough money in the sinking fund, and we're repairing the lift. Is that on track for?
Yeah, exactly.
Give us some other examples.
So, for example, I actually just had a client last week where we did do this body corporate record search. She was buying a unit within a high rise, you can say, and she was purchasing it for about $1.5 million. We did the body corporate record search, which was about $350. And throughout that, it came to light that there's extreme water ingress issues within the whole complex. And they're having a lot of roof issues. The body corporate did struck special levies recently, which was payable in September and October. And the special levies that the current owner had paid was $36,000. So that's a lot of money, especially for someone who might be a first home buyer. Not everyone has access to $36,000 to just throw out the body corporate for a special levy.
So in worst case scenario, someone buys a property, and I know these special levies are also tiered to the size of the unit. If it's a unit complex like a one bedder, the special levy is going to be cheaper than a three bedder or a penthouse.
Yeah,
proportionate to the the unit size in the complex. So it's, I guess, fair. But what, say you don't have the body corporate investigation and someone buys a property where a special levy is overhanging on the property, what options do they have there if they're just hit with this 36,000, how do they pay it, or what options there?
So like the standard REIQ contract breaks up special levies into two portions. One where the notice was issued pre-contract, so the pre-contract date before a buyer has entered into the contract, or after. So depending on when it was raised, that's when, that's who the special levy would be payable by. So unfortunately, like if that isn't done and you're just getting a Form 33 from the body corporate right before settlement, and then you find out there's $36,000 to pay, there really isn't much to do.
Yeah.
And this just goes back to when I said that a due diligence clause is paramount.
So although the agent should be disclosing any special levies in the contract, it's just critical to have that due diligence clause to, I guess, take control of the situation and put the control in our hand and not the vendor.
Yeah, and now with that seller disclosure regime that has come into place from the 1st of August, a Form 33 from the body corporate is available and must be included in that seller disclosure statement. But unfortunately, a lot of the times, buyers don't read it, or they might just not understand all the figures that are in that disclosure statement. But something like a special levy where it has been recent will be disclosed in that.
And so going back to, we've put in the special levy, the special condition for the due diligence clause. We've also got our standard, I guess, in Queensland, building and pest and finance, our 5-day cooling off. But what other things would the due diligence clause come into play at?
Yeah, I think the due diligence is just an opportunity to really thoroughly investigate for yourself and be satisfied in all aspects. And if you're not, then you have a right of termination and to also get your deposit back.
You've known me long enough. I love the grey zone, Mary.
Yes.
Does it cover cold feet?
If you come to us and we draft it, it can cover cold feet.
Okay, but not all due diligence clauses will cover that.
Yeah. So there are a couple of key things in there. It has to be in the buyer's absolute discretion to be able to terminate. I have seen some due diligence clauses, and I will say I have drafted some for sellers when I'm acting for sellers where we make it very specific on the ways that a buyer can terminate, and that they have to also provide evidence when they want to terminate. So, you just need, as a buyer, a very buyer-friendly one that we can terminate for any reason and without providing a reason.
So you're trying to tell me that ChatGPT is not going to draft this?
ChatGPT is not your friend.
Very good, cool. And it's important to understand, I guess, like there is the cooling off. Is it a special condition or term?
It's a statutory right.
Yeah. So, and every state will have it. Queensland's 0.25% in the first 5 days, but every state is slightly different. So it's very important to understand the statutory cooling off period for each state and understand that there is a fee to cool off. So again, the due diligence clause is potentially quite important.
Yeah, because then you get your full deposit back as opposed to losing 0.25% of the purchase price.
Correct. Yep. Sweet. So let's get into the building and pest, because that's probably a good segue there. That probably building and pest would be the second most common reason that contracts don't proceed, and finance is possibly the most common. And third, do we park cold feet? Third most common?
I don't see it that often, to be honest.
Cool.
By that point in time, buyers are very emotionally invested into the property and they want it.
Very good. So, right, building and pest. We've found a property. We've engaged a building and pest inspector. We're inside our initial 2 weeks, which is fairly typical, can be 1 week or less. What rights do we have with the building and pest in Queensland?
See, I actually don't love the building and pest
See, the
condition.
buyer's agent does. The buyer's agent loves the Queensland building and pest condition. So this is one of the areas that we can have some fun.
So I'll tell you why I don't like it, and then you can tell me if you agree or not. I mean, I always do our due diligence clause for the same period of time as the building and pest, because unfortunately with the building and pest clause, you have to act reasonably when you're terminating. Now, what is acting reasonably differs from person to person.
I just want to jump in. Let's presume that this conversation is taking place on a contract without a due diligence clause.
Yeah.
Cool.
Okay.
Here you go. And we'll come back to the DD clause to highlight its importance.
Okay. Well, so it really depends on what are the issues that have come up. Obviously, if there are structural issues like water is getting into the property, those are big issues that could cost hundreds of thousands of dollars to fix. I don't think that there would be a dispute there.
Yeah.
But if you start seeing that there's all of these minor defects in the property, and a layperson walking through the property could probably see majority of those, I don't think that that would be enough to actually be able to terminate under the building and pest condition. It could get challenged. And then you're stuck in a, no, we're terminating, give our deposit back. They're like, no, we're not authorizing the release of that deposit. And then it just becomes a legal battle.
Yeah. And this is like I touched on at the start of the episode, it's so important to have a good solicitor in your corner when you're doing this, because the key word in that whole building and pest clause is reasonable. And I would argue that if the client or the buyer is in Victoria, the property's in Queensland, and you've relied on and let's presume, just to paint the picture better, it's in your buyer's agent might be in southeast Queensland and the property's in North Queensland, is relying on a video walkthrough from a third party, let's say a property manager that we're going to introduce the property to when we buy it and it's an investment, is relying on that video walkthrough as your initial point to proceed with the purchase reasonable?
To proceed with the initial purchase, yes.
As in to put in an offer, because you're relying on that video. But then regardless of what's in the context of the building and pest report, whether they're large or small, if you had identified them yourself walking through that property, and I wouldn't have proceeded with that purchase if I had seen these.
Yeah.
And that's where the grey area is, I guess.
Area.
And it's that term reasonable. So I guess highlighting the importance of having...
Like if there is a couple of screws missing, the bulb needs to be changed, I don't think that those are reasons that would allow termination. But if it starts adding up, especially for someone interstate, I think that there's an argument that could be made. Yeah. But we're going into the grey area of the law.
Yeah. And hence having that solicitor that will be offensive in this situation, because I've seen solicitors who are defensive and passive and solicitors who are offensive and I won't say aggressive, but know their law and will fight for their client is critical. And that's why we don't want to go to, I guess, cheap and nasty, online, conveyances and stuff like that.
But I think, Kane, that's part of the issue. A lot of people don't really know the difference between having a conveyancer and having a solicitor. A lot of the times, anytime they're purchasing a property, they make reference to a conveyancer. But I think, having a lawyer who has gone to law school, who knows the law, can defend you obviously much better in those times that you need it.
Yep. And I'm just going to take the opportunity for Queensland that we do have that BNP clause with reasonable, that if we do identify many issues or, and let's call them small to medium, there is great opportunity to negotiate either they get repaired or settlement adjustments in the buyer's favour. We have a lot of leverage with that clause there for the Queensland buyer to get items rectified or monetary settlements. And I'll just jump in and I guess I'll explain why this is sort of relevant and why we're talking about it compared to Western Australia, where the clause is it must be majorly structural that the vendor's not willing to fix. So no matter how many death by 1,000 cuts, if they're not noted to be major items and structural that the vendor's not willing to fix, you're proceeding with that purchase. Victoria sort of sits in the middle with it must be a major item noted on the report for you to get out of the contract. So probably in those states is even more critical. I know Mary will argue it's always critical to have the due diligence clause, but obviously in WA and Victoria, it's you've got very little rights and you're not relying on the wording of the reasonable interpretation. So cool. Any more on BNPs?
I think obviously just getting that due diligence clause in. Cool. That's just my recommendation.
Excellent. And where next? Finance. Mm-hmm. So in Queensland, generally we're going to have on an offer either a 7-day or 14-day finance clause. Many would like to line it up with the BNP. So, you're in your conditional phase, 14 days finance, 14 days BNP, 14 days due diligence. But to make our offers more attractive, sometimes we're going to drop that back to 7 days finance. Just talk us through just the clause in general and what it's protecting and I guess what it's not protecting.
I think there's a misconception where people think that a finance clause is just a get-out-of-jail-free card, and unfortunately it's not. As part of that condition, you are required to do everything necessary to get formal approval. So you have to go through the motions of applying to your bank and submitting all your documents. And then if you get denied, well, obviously approval hasn't been received. But some people believe that, you don't have to go through that motion and you can still terminate under the finance clause, which is actually incorrect. It can be seen as an unlawful termination, and you just never want to put yourself in that position. So again, going back to that due diligence clause.
Cool. So what happens, like we get our finance and we're happy to proceed. What's the process if we're not pre-approved, we've gone through the finance and we've tried, and the bank comes back and says, sorry, not happy with some previous credit activity on your credit report or insufficient funds to meet settlement. What's the process from there?
So my first step would be obviously just having a chat with the client, seeking their instructions, and then we could terminate the contract under that finance clause, and their deposit, whatever deposit they've paid so far, would be refunded to them.
Yeah, so we get our full deposit back under that clause. So, and in Queensland, we can have a split deposit when we sign the contract just to make the vendor and the agent happy. We might pay 1, 2, 5,000 at signing, and then a balance of maybe 20, 25 K or 5%, again, whatever's been negotiated, and that's paid unconditional after finance.
Yeah.
But whatever's been paid at this point would be refundable under that clause.
And this is why I think it is better to split those deposits up, because why have $20,000, $25,000, $50,000 tied up at the beginning and then having to wait for it to then be released back to you, which could take however long. So it's good to have a smaller amount at the beginning and then the larger sum once you go unconditional, you're going ahead with the purchase.
Yeah, perfect. Cool. So while we're at the conditional phase or the contract, so we've gone through finance, building pest, due diligence. What else? What about any, working order, chatels, any other special conditions we're adding in?
I think if we're talking about a standalone dwelling, one condition that I do like adding in, with the standard REIQ contract, the next business day after you enter into the contract, the risk of the property actually passes to the buyer. A lot of people think that condition in the contract just relates to having to obtain insurance, which that is definitely part of it, but it's more so than that. So what we do is we amend the standard terms to include a special condition that the risk of the property will remain with the seller until settlement. And so if something happens to the property from the contract date to the settlement date, that burden and onus is now back on the seller to actually have to rectify those. Because if that hasn't been amended, majority of the time, I would say probably 99% of the time, the response back will be have the buyer call on their insurance to fix it.
This is such a contentious one. It's so in many other states, for context for the listeners and stuff, the risk doesn't pass to the buyer until settlement, and that's just the way those states are. And that's how it should be, because just talk us through the scenario, and we could probably do a whole episode on this, but we've got due diligence, building pest, finance, we've proceeded with the purchase, we've paid, 5,000 of deposit and maybe another 25 at unconditional. The property burns down. It's not unconditional yet. The buyer has the right to terminate under their due diligence clause that their solicitor has drafted and protects them with changing their mind or any reason that they deem they'd like to terminate. And in this instance, the property's burnt down, in that conditional phase of the contract, take over.
I think that is a very extreme example, because if that did happen, there are there's lots of case law on this topic. So what we have found is that the home must still be habitable. So you still have to be able to go in there and live in there. But if it has completely burnt down, well, I don't think that there's any sort of dispute at that point in time, whether the buyer needs to continue or not.
Well, let's go back to probably more common than a property burning down, like 2019 Australia Day floods in Townsville. There was literally thousands of homes that flood. Floods occur in many regions across Australia. Where's the definition of livable? And who's taking on, the burden of the repairs if the buyer pulls out in the conditional phase? The vendor's got this property. Where do we end there in a legal battle?
Well, it just depends. Yeah. Do you have that special condition in there or not? Because if the special condition is in there, well, that onus is now back on the seller. The seller needs to fix that property and call on their insurance. They should have insurance for the property.
Yeah, but if they don't have the special condition and the buyer wants to terminate at the 2-week mark under their due diligence clause, but they haven't got insurance, even though the buyer's not proceeding with the the purchase, they're still going to be responsible for the repairs?
The buyer?
Yeah.
No, because it's still conditional, and we would get them out of that contract ASAP.
So they wouldn't, yeah, okay, cool. So I think the takeaway here is obviously having a solicitor that's across all this, understanding the responsibilities for each party, but also having the special conditions for the buyer's protection proceeding.
I think that when we do our pre-contract review, that's really an opportunity for us to get to know the client, but also figure out more about their actual circumstances. So I have had situations where a contract has come to me for review, very basic contract, have just had like a 15-minute discussion with the buyer. And then at the very end, they just make a small comment that, oh yeah, we're also selling our house and we need the money. So, it's that opportunity that we get to actually understand the circumstances and now know that they need the money from their sale to purchase this property, to then make these two contracts linked and subject to the sale of their property.
Which obviously many sort of, subject to sale scenarios play out. And I guess me and Mary have worked on many clients together over the years, too many to count. Mary lives in lawland. Kane lives in buying property land. And look, I'm not going to lie, we've locked horns a few times.
I agree with that.
And we can definitely present an offer, and we can put in every special condition under the sun and mitigate almost every risk there is, where we could proceed with full control. But then, as property investors, we're looking for markets that, we don't always, every time we put an offer in, we're not always successful. And that's a good sign. We don't want to be successful 100% of the time. We like to see market heat, where the heat is creating competition, and that's essentially what's driving prices through, a good mix of supply, demand, and all the market conditions we go looking for. But what that means is that in a lot of cases, we're in multi-offer scenarios, and in a perfect world, we'd have all our special conditions there, but we might be competing with an offer that's no finance because they've sold the house, they're a cash buyer, and they've got no due diligence clause and just a BMP, or the sales agent in many cases, you don't need a BMP, it's only 5-10 years old.
Of course.
So I guess we have, we've butted heads on this a few times. Where's the happy medium here?
I think what we have done in the past, because you have hit me with some contracts that have nothing in them, except maybe a building and pest clause. We get everything done with the buyer within that conditional period. So whether they have a due diligence clause or not, our recommendation is always to do it. And we get it done within that, whatever it might be, the 14-day building and pest condition period. Because if there are issues, there's still rights that the buyer has, whether that's statutory by way of the REIQ standard terms. Now with this new seller disclosures regime, more rights come that way. So regardless of what's in there, we will still always try to mitigate the legal risks that come with purchasing a home that don't really know much about.
Yeah, very cool. So we've gone through a fair bit of the contracts and that. Where to next?
So I guess maybe common mistakes that we see.
Cool, yeah.
Yeah.
In our offer scenario or contract or
just like holistically.
Yeah.
I think sometimes buyers take on too much of what the selling agent says and they believe every single word. I do know that there are amazing selling agents out there who are 100% truthful, but at the end of the day, the selling agent has the seller's best interests at heart. Yeah. So you need to make sure that you have your own team around you, whether that's the buyer's agent, a lawyer, a broker, everyone that will work for you.
Yeah. And just the sales agent's job is to be the best friend of the buyer.
Absolutely.
To make them pay as much as possible with the least amount of protection, because they're fighting to get as much protection for the vendor. So they're going to be super friendly to you and, tell you and guide you what way to go. And what conditions to have, and you get your building and pest report back, for example, the sales agent's going to say, yep, you're good to proceed. And for the untrained or unknown buyer, they're just going to say, well, the sales agent said, proceed, so I'll satisfy the building and pest. Yeah. Obviously, there'll be a fair bit that can be negotiated there. What else are we looking out for when dealing with the sales agent?
I think my piece of advice is take what they say with a grain of salt.
Yeah.
In the most respectful way.
Yeah, and it's like every industry, buyers agents, solicitors, sales agents, there's good and bad, there's ethical, there's unethical. And, we're talking about mitigating against, the very small percentage that would be, misguiding or misleading to people. But ultimately, the takeaway is to have your A team there where you are mitigating as many risks and they are acting in your best interest.
I think also with that building and pest, so if it has come back that there are certain issues or things that need to be fixed, sometimes I have seen buyers, underestimate the renovation costs. So I do like what we do, which is to negotiate a reduction in the buyer's favor so that they're not really putting all of that out of their own pocket. They're getting compensation for it to then be able to fix those issues.
Yeah, I think the negotiations with the BNP and we can also extend, remember, so the BNP reports come back. We've identified maybe some high moisture readings in a bathroom wall or a bedroom wall that's adjacent to a bathroom. Quite typically it could be purely just water weeping in through the shower tap flange, and it's literally a handyman and a tuber sealant to fix that. But, worst case, it could be a ruptured water membrane where we are talking $15,000, $20,000 and we require flood test, pressure test and stuff. So we can extend as well. So we can extend our BNP and say we're not satisfied. We're still looking and want to work with you to proceed with the purchase. We're going to extend it by a week so we can get some quotes so we know the actual hard cost of the repairs before proceeding.
I think just with that, of course, we can always put in that request to extend, but, strictly speaking in accordance with the terms of the contract, the seller doesn't have an obligation to agree.
100%.
So, if they have a backup buyer in the background, they may wait for that 5 o'clock to tick over. So, yeah.
So we can request an extension. We can choose to terminate or we can choose to proceed. We do have our choice of which way we want to go, and it all depend on the level of repair.
Yeah.
But a good buyer's agent and would have contacts that could potentially move quickly to get quotes through, look at the report, and hopefully act within the standard 14 days.
What I have seen to be very successful is when obviously there is a buyer's agent involved. They are liaising directly with the selling agent, and they put all of those through the selling agent first, so that then when we as solicitors send through the formal request, the seller's already aware of it and they've already agreed to it. So they're just giving formal instructions to the solicitors to agree, which obviously speeds up that whole process.
Buyer's agents doing the deals, solicitors just formalising it. Cool. So we're now looking at what's the lawyer's role in all of this?
I think our role should always begin before a buyer signs the contract. That's when we can, first of all, review and make sure that the key commercial terms are actually reflected in the contract. We have discussions to see whether there's any special conditions that need to be drafted, any amendments made to the contract. So everything really pre-contract we would like to be involved with. And then obviously once we've entered into the contract, we are the ones that order those legal searches for buyers. We will also review them, of course, once they come back, and we prepare property reports for buyers. If there is anything that is adverse or red flag, at least at M&M Lawyers, we give our clients a direct call right away. If everything is pretty standard, there's nothing that jumps out. We just prepare the report and we give it to the buyer to read and then come back to us once they have read it and have any questions. I think having a solicitor involved early on is just a protection that money can't buy, to be honest, because it is one of those, it's probably one of the biggest investments that a buyer will make. And to spend a few $100s to have a pre-contract review could save you hundreds or thousands of dollars down the track.
Yep. And just on that, I think that's a good point or segue to touch on the difference between like a conveyancing firm versus an actual solicitor. I've seen clients like say, no, I don't want to use your recommended solicitor, Kane, because my auntie is a solicitor or my auntie's a conveyancer in whatever firm, or my neighbour or my friend or my sister, so I'm going to use them. I'll share my thoughts on that in a moment, but just explain from probably more of a qualification and workflow and control of the contract, the pros and cons of a conveyancing firm versus an actual lawyer acting on your behalf.
Yeah. Well, if you have a conveyancer who's acting for you, well, they're not legally trained. They are ones who work underneath a solicitor. So sometimes trying to get something back from them might be delayed because they need to first for example, draft their email, run it past the acting solicitor, make sure it's all good before they send it out to a client. So obviously it's just delays where sometimes you need to act fast. You need decisions made, you need to know your legal options, and you need to move quick, especially in this market. So having a solicitor bypasses all of that. You know that you're in good hands, someone who will protect you legally.
Yeah, I guess I'll share my thoughts as well because I 100% agree there. But, you've got a conveyancing firm that they might only really specialise, that they would say, or practice conveyancing of residential purchases. So they're a volume style business. So they might have a discounted or a cheap fee and they're based on turning over volume. But like I touched on at the start of the episode, it's fine when everything goes smooth. But when it turns to custard and you need to be on the offensive, whether it's a building a pest issue, an insurance issue, finance, whatever it is, maybe you're requesting an extension because your finance hasn't been approved in time. And you can only get a 0755 number for the conveyancer and you have to get through the gatekeeper of the receptionist or whoever's answering the phone, and you can't actually talk to the solicitor who's overseeing the conveyancer. Like you mentioned, speed is critical in many cases. There's strict deadlines and timelines, whereas having an actual solicitor and most importantly, a mobile number to contact that solicitor who's aware of those deadlines, I feel is critical, that all of a sudden you're talking to the decision maker and you can, workshop it or whatnot, or talk through it with the client, solicitor, the buyer's agent, whoever, get the sales agent to view if we need to, in a speed and timely manner to meet deadlines. You're not going through gatekeepers and stuff. So
just touching on that, I think a lot of the times I have seen conveyancers where in the email requesting an extension, for example, for finance, that email only contains, on behalf of our client, we're instructed to request an extension of the finance date to 7 days from now. But I have found that if you take the time to actually explain why, the likelihood of someone granting that extension is much higher. So you can say, our client's broker has been jumping through hoops, has done X, Y, and Z. They're confident that the client is going to get formal approval, but they just need a little bit more time. And so when you give a little bit of a background, I found that it's more successful and you get that extension request through. So I think dealing with a solicitor is someone who actually takes a little bit more time
and
with
pride
in their work, as opposed to pumping out conveyancing. Because, for example, with our firm, we don't just take on every single conveyance. We have very limited number of what we do, and that's because of the amount of time that we invest into every single client. We don't have high numbers where we're turning around 500 conveyances a month.
Yeah. It sounds terrible to me. And I think, to put it like you said, context is critical. When you're asking for extensions, if you just punch out, hey, we need 7-day extension on finance, if 2 days is sufficient, you only want to ask what you need and give context on why. Like many banks, especially at the moment, are processing a lot slower.
Yeah.
Especially with like the first home guarantee scheme. The recent changes last month really just increased that scheme to so many more people. Banks were overwhelmed with volume of pre-approvals and stuff, which blows out their assessment times, which then causes buyers to request extensions. If you're going and requesting that extension without context, you can lose a purchase. And imagine if you are buying your dream home or something, losing a purchase because you didn't have someone on your side to give that context. And that's where the buyer's agent and, the lawyer acting in your corner is critical, I guess. And, we're talking with these high volume conveyancing firms, you're talking the difference, a couple of $100 from an actual lawyer holding the file all the way through to settlement versus a conveyancing firm. It can only be a matter of a few $100s. Is that really the savings that you want to make when you're spending, $750,000 to $1 million to 1.2, whatever it is on a purchase?
It's not the time to cheap out.
No, I'm sure there's more other areas in the purchase that you can save a couple of bucks. So sort of proceed with caution if you're going down the path of a volume conveyancing business, but each to their own, I guess. Mary, it's been wonderful. Any final thoughts? Top takeaways?
Top takeaway. I think I'll just leave with one, and that is have a solicitor involved before you sign the contract. Have us review it, have a proper discussion, get to know each other and understand your circumstances so we know what you're wanting in that contract and that it reflects what you need and that you're protected.
Yeah, awesome. And Where can people find you?
Our full company name is MNM Property and Commercial Lawyers. Our business name is just simple, just MNM Lawyers. If you forget it, we're like the chocolates. We're also very sweet. But we can be found... Why are you laughing like that?
I don't know.
We can also be found at mmpcl.com.au.
Yep.
And our phone number is 0731842424.
Cool. And if you forget that, just rewind or contact me and we'll put you in touch.
Always happy to have a free, no obligation chat.
Until next time, thanks.
Thank you.